All right, court call CR 21193, State versus Audrey Jean Thompson. Ms. Thompson, if you'll come to the podium right here in the middle. All right, Ms. Thompson, you're set for arraignment today, and I believe you were present in the courtroom earlier today. Is that correct? Okay, why did you leave? Okay. All right, well, I'm glad you returned because I wasn't sure, so we didn't know if we were going to issue a warrant for your arrest. So. Okay. Well, next time something like that happens, you need to let somebody know. That way we're not just wondering, because a lot of times people show up here and they listen a little bit and then they take off and they never come back. We have to go find them. Okay. So Ms. Thompson, what is your plan on an attorney? Are you going to hire an attorney to represent you?
Yes, sir. I'm gonna hire, I think his last name is Ronnie.
Where's his office? Out of Tyler? I don't know. I've never heard of an attorney by that name, but that doesn't mean that there's not an attorney. So how long is it going to take you to hire him? Have you already tried to? Do you know how much he's going to charge? And you haven't paid him anything? Do you know him personally? I mean, do you know him, like, is he a friend or an acquaintance?
I know him through a friend.
And so you met with him at his office, but you didn't discuss how much it was going to cost to represent you?
No, I explained to him what's going on in this county and meeting and stuff, and he said that he's interested in everything.
How much money do you have saved up towards your attorney? $1,000? You have $1,000 set aside to pay an attorney?
Yeah.
All right, so this is what I'm gonna do, Ms. Thompson. I'm gonna reset you for 2 weeks. Okay? And whether you hire that attorney or another attorney, I don't care. I just need you to show back up with an attorney.
Yes, sir.
Okay? So that's gonna be on July 27th. And that's gonna be at 9 a.m. I'm gonna fill out a form. I'm gonna have you sign it. I'm gonna give you a copy.
I apologize.
No, I understand. I mean, I don't fault you for that at all. And I'm glad you showed back up after you're contacted, but just the way that it works is if you don't show up, we issue a warrant for your arrest, or if you show up and you don't check in and leave, then a warrant issues. I'm also writing on here what you're charged with: burglary of a building that carries a range of punishment of not less than 6 months or more than 2 years confinement in prison. So it's a very, very serious charge, and there's no parole at state jail. So this is something that you're going to need to get an attorney on pretty quickly. Okay. So when you come back on July 27th, I'm going to have you sign this form right here, and then we're going to give you those yellow copies. Okay. Thanks, sir. All right, Ms. Thompson, you're free to go. You're welcome. I'm good, man. That's all we got. So you need to head on, do what you got to do. Look. Ms. Taberham, just let me know when you're ready at the jail.
We will.
Is her last name P-I-I-E?
Judge, Daniel Hunt is ready with Mr. Atkins. You can do it here.
All right, this is cause number CR 2237, CR 2146, State versus Chad Edward Atkins. We are set today on status of the records production. I believe that Mr. Hunt had issued a subpoena or had a subpoena issued requesting the personnel file of Officer Mackenzie Chandler of the Grand Saline Police Department. The state filed a motion for in-camera review, citing that those were confidential records subject to in-camera review. The state and Mr. Hunt both provided information to the court regarding those records and whether or not they should be produced or reviewed in camera. The court reviewed the case law provided by Mr. Woodwike of the DA's office, found those records to be confidential, and has conducted the in-camera review. On the basis of the court's review of the records, the court finds that there exists no mitigating or exculpatory evidence in those personnel files and records that would be subjected to disclosure by the state or by the court over the confidentiality of the records. So the court's going to deny the production of those records to the defendant in this case, and the court will have those records filed with the district clerk's office and sealed for appellate review if that's the case that's required.
Well, and Your Honor, if I could, just for the record purposes, I would like to renew my objection to the court renewing those records and the state representing the Grand Saline Police Department. I believe that would be a civil matter for the Grand Saline city attorney to handle, and not the criminal district attorney's office defending the city and their personnel records. So that's the basis for my objection, Your Honor.
Okay, the objection is overruled, and the court, in reviewing the case law, found that the court has a duty to enforce the confidentiality provisions of, or the confidential nature of those records with Mr. or Officer Mackenzie Chandler's position as a police officer. So I don't view it as the DA's office representing the city of Grand Saline, rather that the court has an obligation in its capacity to determine, one, whether or not the records are confidential or should be deemed confidential. And then if they are, then the court, as case law holds, is instructed to review that and determine whether or not they should be produced over that confidentiality for mitigating or exculpatory purposes.
And also, Your Honor, for purposes of the record, I would like to request a writ of attachment for the custodian of records of the Grand Saline, city of Grand Saline, who did not produce those records to me under subpoena by the date that was on the subpoena. So I'm now requesting a writ of attachment for her, or him, whoever the custodian of records is for the city of Grand Saline.
I believe, I could be wrong, but I believe a writ of attachment has to be requested in writing.
Well, I'll file that.
Okay. All right. As when that is produced and provided and requested, then the court will rule on that.
Okay. And then also, Your Honor, this morning I actually filed, after doing a little bit of research, I filed a motion to recuse or disqualify the sitting judge based on previous contact with cases involving this defendant when you were the district attorney. In 2016, the defendant was convicted of evading arrest with a motor vehicle. And on at least one occasion during that prosecution, when you were district attorney, you made a plea offer to the defendant's then attorney, Nolan White, to take care of that case. And so I believe that under Code of Criminal Procedure, Section 30.01, that would disqualify you from sitting as the judge.
And what was that case number? What was the previous case?
The previous cause number was CR 15-00203.
And did you provide that information to the state of Texas?
I copied them on this motion to recuse, yes. And that cause number is in there.
And when was that filed?
Today at 10:28 a.m.
Okay. So that's not been presented to the court or to the state. So the court will set that for a hearing. I will review it once it's presented, but being filed today, it hasn't made its way through the clerk's office and then through my coordinator and then to me. So we'll have to set another date for that to be considered.
Understood.
All right, so let's set this then for status on the motion to recuse. Are you available on August 12th or August 24th, Mr. Hunt?
Give me just a second, Judge. Get my calendar up. I'm sorry, August.
12th or 24th.
August 12th, I am available.
Okay, let's set it for status on recusal, or status on the motion to recuse for August 24th at 1:03.
24th? or
I'm
12th?
sorry, 12th.
Okay. At what time? I'm sorry, 1:30?
1:30 if Mr. Atkins is in jail. It'd be 9 a.m. if he's on bail.
Okay.
And so I'll tell you, Mr. Hunt, what we'll do is whenever the state has an opportunity to receive and review that motion, the practice of this court has been, because we have had other cases where I have voluntarily recused myself whenever I've had an active participation in a prosecution of a case that is pending before the court, that the state will notify this court. And if I find that I've been an active participant in a case as the case law directs, then I voluntarily recuse myself and refer the case to the presiding judge of my region, and then he makes an appointment. So if that's the case, and I learn of that information before August 12th, then I may rule on your motion to recuse before that date.
Okay, thank you, Your Honor.
You're welcome.
May we be excused?
Yes, we'll see you back on August 12th.
Thank you, Your Honor.
You're welcome.
Judge, we're ready for Mr. Covey with Mr. Noel.
All right. Court call CR 2327, CR 2154, State versus Michael Shane Covey. Go ahead, Mr. Noel.
Did you, well, to start off with, I don't know that I remember exactly what day I got it. It was sometime last week, I think. Received some information regarding some Andrews Center notes regarding Mr. Covey. I was here about 7:45 this morning. Mr. Covey and I talked about multiple things. Mr. Covey got upset. I'm going to backtrack a second here so the court knows. Well, the court probably knows I've been doing this 37 years. I was on the Andrews Center Board of Directors for 6. For really personal information, I have a son that is an Andrews Center patient. So I am not someone that doesn't know that situation. Now, with that said, in conversations, and I think Mr. Covey thinks I'm just getting a little too personal, but have to know things. So I believe that some of the potentially mental health issues involve what I see many times and have seen many times, issues of polysubstance abuse. I think some of the issues described in the Andrews Center notes that I received, and those notes are dated June 29th, 2021, probably involved issues of, to some extent, psychosis brought on by at least methamphetamine use. Now, Mr. Covey and I have spent another hour together this afternoon going over plea papers. I believe he understands what the charge is. I believe he understands the consequences of the entry of his plea. I believe that he understands that it is a long-term probation, which includes safety, and Covey's credit, Mr. Covey says he understands that he needs help with his drug situation. I think one of the reasons that this offer was made, as I recall, is because that was part of what the family hoped for Mr. Covey would be to get help with the long-standing drug problem. So I believe that today he is competent to proceed today, enter a plea on this case, and just for the court's information, we're pleading on the injury to it. In this case, it's actually a disabled person, and the state is offered for $12.45 the possession of controlled substance.
Okay. Okay, and Ms. Heisel is going to give me the terms of the plea. Anything else, Mr. Knoll, before we begin on the plea?
I think that's it, Judge.
Okay, go ahead, Ms. Heisel.
Thank you, Your Honor. In clause number 21-00054, upon a plea of guilty to the third degree felony injury to a disabled person, state's going to recommend punishment be assessed to 10 years, TDCJ, probated for a period of 10 years, a fine of $2,500, $180 restitution. Safe P is a condition of that probation. 1245 CR 20327, which is the possession of controlled substance under 1 gram. $290 court costs, $785 reimbursement fee, and I do not show that Mr. Covey has any back time jail credit.
Okay. Did you use those terms as Ms. Heisel read them, Mr. Knoll?
I lost it. I lost the very last thing she said. I think it had something to do with back time.
Yes, yes. So she said the plea agreement is 10 pro 10, safe P as a condition, 2,500 fine, 180 restitution, 290 court cost, 1245 the PCS less than 1, and $785 reimbursement. And of course, with a plea to probation, there would be no credit time.
That's fine. Just the only other thing I'd mention, there was, I guess, an either or offer. It was either the offer that Mr. Covey has decided to accept or 4 years in the Texas Department of Criminal Justice Institutional Division. He made the choice to take the 10% in safety.
Okay. All right, Mr. Covey, if you'll raise your right hand, sir, I'm going to place you under oath.
Yes, sir.
You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. Mr. Covey, your name is Michael Shane Covey, is that right?
Yes, sir.
And Mr. Covey, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And Mr. Covey, tell me about your mental health disorders.
I've been a schizophrenic since I was about 14. I got shot in the head whenever I was 14, walking home from the grocery store with my dad. Didn't go to the hospital. I actually should have. It was my choice. The ambulance driver had looked me over. They actually gave me a ride home because it was a gang shooting, or what they called a gang shooting. So I didn't feel safe walking home. It caused me to stay inside the house for many years. I didn't leave the house until I was like 21. And so actually the time we moved from Oak Cliff to Kent, Texas. And that was around my 21st birthday. I remember getting my first bottle of liquor up in Kent, Texas. And that was when we moved from Oak Cliff. So from the time I was 14 up until 21, I stayed in the house. I wouldn't leave the house. It caused me to be a real bad schizophrenic. It took me a minute to get out of the house in Kent, but I did. It took a lot of trust. Just people, my surroundings. I didn't trust anybody. I wouldn't even. I don't trust. So my theory is, don't even trust your own mom. And that's the way I was, and that's the way I am. I don't. But to this point right now, I know I love my mom, but I don't trust her. I really think that they had hired people to kill me. That's been my theory ever since some personal problems that took place about 5, 6, 7, 8 years ago between me and an ex-girlfriend, and that was her statement. And ever since then, I didn't trust my family. I locked myself in the garage for about 3 years, about three and a half years, something like that. And I wouldn't leave. I mean, I'd go to the inside of the back side of the house. We had a sliding glass door. I'd grab cans of tuna and I would go outside with my pup, my German Shepherd, which I still have. And I'd go back out to the garage and we'd eat out there.
Well, let me, and I appreciate that, Mr. Covey. Let me ask, are you currently on medication today for your mental health disorders?
Yes, Your Honor.
Do you feel like those medications are giving you the ability to have a rational understanding about what's going on here in court today and these proceedings and your paperwork?
Yes, sir.
Okay. And do you feel like you understand everything that you've read and signed?
Yes, sir.
And is that your true and correct signature that's in the plea papers?
Yes, sir.
All right. And in this case, you've been represented by,
I'm sorry, Judge. I guess I do mean to interrupt you. As far as he is on several medications, and I specifically asked him, not sure what all of those are. One of them he's been on about 2 weeks, and I think he said as far as new ones, and that's what I asked him about, there's probably some that he's taken for a while. Another one that he's been on
Yes, sir.
about 6 weeks. So there are medications that are newer, but again, I believe he understands what he's doing here today. He didn't know what all of them are. I assume the infirmary here has that list. Obviously, any medications that he would need to be on when he's out of safety, I would want that to be a part of any term and condition of probation to continue with Andrew Center and whatever their recommendations are. Sorry, Judge, thank you.
it's okay. So you do believe him to be legally competent today?
I do, yeah.
Okay. And Mr. Covey, your attorney, Mr. Knoll, are you pleased with his representation of you?
Yes, sir. Yes, sir. Your Honor.
You feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, Your Honor.
Is there anything about this paperwork that you don't understand?
Yes, sir.
Okay.
It was hard to understand some of it at first, and I had to ask him, and he pretty well made me understand, or gave me the lecture of understanding.
Judge, I think the main thing he didn't understand was the 1245 concept that the case would, so to speak, disappear. The punishment in this case would take care of the other case. So we went over that a few times till we both understood. And I understood that he understood.
Okay.
Sorry.
That's fine. It's not.
Okay. So Mr. Covey, I've got to go over some things with you. I have to tell you that you are charged by indictment with a third-degree felony offense of injury to a child, elderly, or disabled individual. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice. I see here that the plea agreement is for this court to assess your punishment today at 10 years confinement in TDC, but the state's recommending that that sentence be suspended and you be placed on community supervision for 10 years. That means that you will be convicted today and you will receive a 10-year sentence. But so long as you comply with your terms and conditions of your community supervision, you're going to be allowed to be free once you get through your Safe P program, which is a part of your probation. Once you're out of that, then you're going to be in the community. And so the plea agreement does legally fit within that range of punishment. Do you understand today the plea agreement and the legal range of punishment in your case?
Yes, Your Honor. Yes, Your Honor.
And you understand if I place you on probation and you go to Safe P and you successfully and you get out, if you violate your conditions of community supervision, the court would issue a warrant for your arrest. The state would be required to prove to me that you violated. And if they do so, then the court can revoke your community supervision and I can assess this 10-year sentence upon you. You understand that?
Yes, Your Honor.
And understanding those things, you still want to go forward in this case?
Yes, Your Honor.
Okay. All right. Then, Mr. Covey, let me ask you then, how do you plead to that charge? Are you guilty or not guilty?
Guilty. Guilty, Your Honor.
And are you pleading guilty because you are guilty of committing that offense?
Yes, Your Honor.
And has anyone threatened, forced, or pressured you to plead guilty today?
No, sir, Your Honor.
All right, the court will accept Mr. Covey's plea of guilt. Mr. Nolan, any objection to states one?
No, Your Honor.
All right, states one, the evidence in this case is admitted, and the court does take judicial notice of Mr. Covey's judicial confession. Other than a recitation of the facts, is there anything further from the state?
Just your honor, we would like to put on the record the state is in compliance with victim notification. We have not received any response back from the victim and this father, his mother, who is his legal guardian. However, the night of this offense, they did indicate to police that they didn't want Mr. Covey to be in trouble per se, but they thought he needed drug treatment help. We believe that our plea offer is in conjunction with that and would be with the wishes of the family.
Okay. And Mr. Knoll, can you hear Ms. Heisel okay? I know we've been having some difficulty with our microphones. Can you hear her okay?
Yeah, it was a little difficult, but I did hear everything that she said, and that was actually my understanding as far as the family's wishes, and has been my understanding for several weeks, actually,
Okay.
as far as, in particular, the drug treatment issue. Judge? Oh,
Yes, sir.
did you just mute yourself?
I did. I asked Ms. Heisel to get a microphone and bring it up here. So she's about to read the facts of the case to me. And so I just asked her to bring that with her. So, all right, go ahead, Ms. Heisel.
Thank you. Can you guys hear me at the jail better?
That's fine.
He gave you a thumbs up.
Oh. Judge, the law enforcement was called out to Mr. Covey's parents' residence on report of a disturbance. When they arrived, Mr. Covey's mother, father, and brother were present. His brother is an adult, but does have a mental disability. I don't recall off the top of my head whether he has a particular diagnosis. However, the mother stated that he has the mental capability of about a 7-year-old. He does suffer from seizures, and just through the officer's interactions with him, it's clear that he does have some sort of mental disability. The brother had indicated to police that Mr. Covey had come to the parents' house seeking money. They believed he was going to be using on drugs. They refused him the money for the drugs. Mr. Covey was getting aggressive towards the mother, according to the brother. The brother stepped in to intercede on the mother's behalf, at which time Mr. Covey began striking him in the face and head with his hands repeatedly. Mr. Covey was not present at the scene when officers arrived. However, the brother did have a laceration to his head, and visible injury. There was also a 911 call where the mother is on the phone basically while this is happening, and reciting to the officers what's going on more or less in the heat of the moment.
Mr. Knoll, any objection to that summary?
I think that's basically what I recall. So no
Okay.
objection.
Okay. All right. Then based on that evidence as presented, the court will follow the plea agreement in this case. Mr. Covey, the court convicts you of injury to a disabled individual, a third-degree felony, assesses your punishment in accordance with the plea agreement at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence today and place you on community supervision for 10 years. The court will order you to attend the Substance Abuse Felony Punishment Facility, also known as SAFE-P, as a condition of your community supervision. Court will assess a $2,500 fine, $180 restitution, $290 court cost, $785 reimbursement. Court also takes into consideration and dismisses under section 1245, cause number CR 2327, possession of controlled substance less than 1 gram. Mr. Covey, you're hereby remanded to the custody of the Van Zandt County Sheriff and Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. After that, the probation department may have additional information for you, but you will remain in custody until the SAFE-P program has a bed available for you. and I will monitor that. If you're in there longer than I expect you to be, then we'll come back to court and have a hearing about it. But you'll stay in custody until that time comes, okay?
Yes, Your Honor.
Judge, I did check the average wait time on the safety with the probation department this morning. It's about 27 days. So hopefully within a month or so, he'll be in safety.
Thank you for doing that, Mr. Knoll. I appreciate it. All right, so I'm not going to say good luck to you, Mr. Covey, because it's not about luck. Okay, it's about being compliant, following rules, and taking advantage and receiving the help that people want to give you. Okay. All right, so go and do well and accept what the state's trying to give you.
Yes, Your Honor.
All right, you're welcome. Mr. Knoll, is that all you have this afternoon?
I believe it is, Judge. May I be excused?
Yes, sir, you may. Thank you. Appreciate you. Have anyone else that's ready?
Yes, sir. Mr. Scott is ready with Vincent Ramirez.
Court call CR 19-245, State versus Vincent Cisco Ramirez. And are we doing a plea today? Oh,
Yes, sir.
all right. I'm gonna have Ms. Heisel read to me the terms of the, and you need to set that down, and hopefully between both of our microphones. Will pick you
And
up.
Judge, I'm actually gonna ask Mr. Scott too. I don't have a copy of that
Okay.
paperwork with me.
Mr. Scott, can you refer to the judgment for me and just start with the level and then the sentence all the way down to court costs, reimbursement fees? If you'll read kind of that plea bargain section of the judgment all the way down to credit time and just outline what that is for me.
Yes, it's the offense is being reduced to a indecency with a child by exposure. Date of offense, April 17th, 2019, plea of guilty. It's a third-degree felony. Terms of the plea bargain, plead guilty to the lesser included offense of indecency with a child by exposure. Punishment assessed at 4 years, TDCJ, institutional division. Sentence shall run concurrently. Court costs, zero fine, zero restitution. Court cost of $290, reimbursement fees $225, jail time credit of 693 days.
And is it running concurrent to another sentence?
Yes, Your Honor, he pled to a 2-year sentence out of Kaufman County on 2 charges of online solicitation of minor.
Okay, so we don't have a cause number, it's just whatever he's currently serving.
That's right, Your Honor. He was actually bench warranted from TDC to be here today.
Okay. All right, Mr. Ramirez, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Ramirez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Ramirez, you put your hand down. Mr. Ramirez, your name is Vincent Cisco Ramirez, is that right?
Yes, Your Honor.
And Mr. Ramirez, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
And have you ever been diagnosed with any type of mental condition?
Yes, Your Honor.
What have you been diagnosed with?
That I do not know. My family would know that. I do not.
Your Honor, if I could, I filed a motion to have Mr. Ramirez evaluated by Dr. Allen. He was evaluated. Dr. Allen deemed him to be incompetent. He was sent to Terrell for restoration. He's been restored to competency. Today, I do believe that he is competent and he understands what he's doing. I've asked him multiple times as we've gone along today, and I do believe he's competent. Wasn't placed on any medication according to him, so he's not taking any medication, but he's clear-minded today. He knows what he's doing, Your Honor.
Thank you, Mr. Scott. Mr. Ramirez, are you pleased with Mr. Scott as your attorney?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about your case, and do you understand everything that you've read and signed today?
Yes, Your Honor.
All right. Mr. Ramirez, you are charged with a second-degree felony offense of sexual assault of a child. However, the plea agreement with the court is for you to plead guilty to a different charge. It's a lesser charge. It's a third-degree felony offense of indecency with a child by exposure, and that carries a range of punishment of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. That means that the court could not sentence you to anything less than 2 or more than 10, or a jury if you went to trial. And I see here that the plea agreement recommendation at 4 years fits within that range of punishment, and that you would be receiving a 0 fine. So do you understand that full range of punishment and the plea agreement today?
Yes, Your Honor.
All right, and you're asking the court to approve that?
Yes, Your Honor.
All right, Mr. Ramirez, how do you plead to indecency with a child by exposure, a third-degree felony?
Guilty.
And Mr. Ramirez, are you pleading guilty because you are guilty of committing that act and offense?
I'm pleading guilty because I am guilty.
All right, court will accept the defendant's plea of guilt. Mr. Scott, any objection to states 1?
No, Your Honor.
All right, states 1's admitted into evidence. The court does take judicial notice of the defendant's judicial confession. This is a Chapter 62 offense, correct? Has Mr. Ramirez received his copy of Chapter 62?
Yes, Your Honor. He's got it right here in his hand.
Excellent. And he has been presented with the Chapter 62 admonishments that indicate that he's required to register for a period of 10 years after his release from the Texas Department of Criminal Justice. Is that correct?
That's right, Your Honor. 10 years, and yes, he has been provided with that. He's signed off on the admonishments.
All right. Thank you, Mr. Scott. Anything,
Sir.
State?
Your Honor, if the court prefers, I do have the cause numbers for the Kaufman case. If the court would like those. Otherwise, we would just ask the court at this time to take up the victim impact statement as cause.
Okay. Well, since it's not in the paperwork, I'll just indicate that it's going to run concurrent with the Kaufman County causes. I'm going to take just a moment to review the victim impact statement that's been provided to the court. All right, Ms. Heisel, if you can give me a summary of the facts supporting the plea.
Yes, Your Honor. Mr. Ramirez was 22 at the time. The victim at the time was 15 years of age. A friend of hers had asked her for contact on who could provide her with some drugs. The friend gave her the defendant's Snapchat account. They became Snapchat friends and started messaging each other back and forth. There was some flirtation. There was some pictures sent back and forth. Mr. Ramirez indicated to the victim that he could in fact get her some drugs, but that he did not want money in return for that, that he would prefer sexual favors. The victim gives him her home address to come over and do the exchange. There's some touching on both sides. As part of this, ultimately the victim does perform oral sex on the defendant in exchange for the promise of drugs. The victim's mother walks in right about this time. She doesn't see anything because there's a blanket, some stuffed animals, but she's very alarmed at the situation. The defendant leaves and she immediately calls police, where the investigation reveals the facts that relate them to you.
Mr. Scott, any objection to Ms. Heisel's summary?
Not for purposes of the plea, Your Honor. No, Your Honor.
Okay. All right, then based on the evidence as presented, the court will find that there is sufficient evidence to convict Mr. Ramirez of this offense. The court will follow the recommendation and the plea agreement. Court hereby convicts Mr. Ramirez of the third-degree felony offense of indecency with a child by exposure. Court will assess his punishment at 4 years confinement in the Texas Department of Criminal Justice. Court will order him to pay $290 court costs and $225 reimbursement fees. Court will award Mr. Ramirez 693 days credit towards his sentence for the time that he has spent in custody on this charge. And this sentence will run concurrent with any sentence that Mr. Ramirez is currently serving in any other jurisdiction. Mr. Ramirez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you go with the deputy there to be fingerprinted. Whenever you are released from the Texas Department of Criminal Justice, you need to come to the courthouse and make arrangements to pay your court costs and your reimbursement fees. Okay, sir?
Sure.
All right. Thank you, Mr. Scott. We'll be adjourned in this case.
Thank you, Your Honor. May I be excused?
Yes, sir, you may. Good to see you.
Good to see you, Judge.
All right, Your Honor, we're ready with Mr. Chumley and Mr. Ashmore.
Court call CR 21-109, Say versus Daryl Dwayne Chumbley. Set for pretrial. Go ahead, Mr. Ashmore.
Good afternoon, Judge. Mr. Chumley and I received a plea offer today. The offer is that, one, the state would consider probation if we can come up with something that might make it work. The current offer is 8 TDCJ, and this is mostly due to Daryl's limited financial means and his ability to perform successfully on probation. So we're going to ask the court to reset us for a docket call so that we can negotiate with the state and see if we can come up with a final resolution of this case.
Very well. Finds that there are no contested pretrial motions, sets this matter for docket call. At that time, the court will expect the defendant to inform the court whether or not there will be a plea agreement or a jury trial or a bench trial in this case. Mr. Ashmore, I believe I set you for August 24th earlier today. Is that correct?
Yes, Judge.
All right, court will keep you on that same calendar and we will set Mr. Chumbley for docket call 8/24 at 1:30. If Mr. Chumbley makes bail in the case, then it'll be at 9 a.m.
Yes, sir. May Mr. Chumley be excused, Judge.
Yes, sir.
Thank you.
You're welcome.
And now we're ready with Mr. Hobson.
CR 21-123, State versus Mario Antoine Hobson. Mr. Hobson set for pretrial today, Mr. Ashmore?
He is, Your Honor. We do not have any contested pretrial motions at this time. I don't believe there will be any. We did receive a plea offer today, 20 years TDCJ institutional division, no deadly weapon finding. My client has asked to revisit the issue of bond, so I will be filing a motion to reduce, even though I've explained to him that he meets no statutory qualification for a bond reduction. But I am going to file that motion, give the state notice, and ask court to set us on a contested docket that will be on file by the end of the day, and ask the court to set this for a docket call so he may consider this this plea bargain offer that was made today.
Not speak to the judge, please.
No.
All right, court will set Mr. Hobson for docket call on August 24th, and we can take up the motion to reduce bail on that date as well, Mr. Ashmore.
Okay, Judge,
I'm
thank
gonna
you.
terminate, motion to terminate point of order, man. You don't mind? Motion to terminate the point of order. I have the paperwork ready to file.
Mr. Hobson, if you want another attorney, then you have to do one of two things. You have to hire an attorney and have them come in here and file a motion to substitute counsel, or you'll need to file a written motion as to why the court should terminate Mr. Ashmore's representation of you. So follow the rules like everyone else, and the court will hear what you got to say. All right, so we'll see you back on August 24th. If you file that motion between now and then we'll take it up on the 24th.
Whatever. you want. Give me that vote.
No, that was PR one.
I'm gonna put both of those in.
Well, he said y'all are gonna talk about that next.
Judge, I need just a minute, please.
Okay.
My two clients just got in here.
I understand. That's fine.
Sorry. Make you do that.
Your Honor, we're ready. Mr. McAllister.
Court call CR 21-131. Jack Marvin McAllister, set for pretrial today, Mr. Ashmore.
Judge, we don't have any pretrial motions. We are asking the court to reset us for a short docket call. We've been negotiating with the state. We're very, very close to a number. I think a few more weeks and we'll be squared away. So again, maybe 8/24, we'll be ready to enter a plea at that time. We're set for, I can't imagine we're gonna set. This is a case both sides want to resolve, and but like I said, Judge, we're close.
Do we want to do it sooner than that? We could set it on July 27th in 2 weeks.
Just a second, Judge.
That's fine.
Judge, I'm taking my son to camp that day, the church camp, and it's on the other side. It's west, not east. Is there anything else available? Maybe on the 29th?
No, he's not on the contested docket, so we don't need to put him there. August 10th, 12th, or 24th. So if you're going to be on the 24th, we might as well just put it on the 24th. I just didn't know if we needed to do something sooner than later. Are we anticipating probation or time? Time?
No, this will be the offer is TDC time. It's a eight years offer. But like I said, Judge, we're close on resolving a number.
Okay. We'll keep him on the 24th then.
Okay, Judge.
Call.
Yes, sir. Judge, we ready on Clifton Thomas?
CR 2415, Clifton Glenn Thomas. Set for pre.
Yes, sir. Judge, we don't anticipate having any pretrial motions, any contested pretrial motions. We believe we have all discovery. This is on me. We had originally consolidated into Judge Winter's court, realized that there's more going on in your court. We've now got a signed order bringing everything back up here. I'm working with Mr. Woodwike on an offer, kind of a global offer for all the cases. And we just need a reset so we can straighten that out now that we know where all the pieces are on the board. And I believe that order consolidating back upstairs was signed last week, so.
Mr. Thomas has a DWI, is that correct, downstairs?
I think there's 2 evadings, and then there's some sort of alcohol-related family violence hanging out there.
Two evading arrests, no alcohol. 2 evading
Okay.
arrests, one.
Thank you.
Okay.
Sorry about that. That's it.
I think I signed 2 last week that were consolidating. I knew one had a DWI and one had an assault. Okay. All right. Then we'll set Mr. Thomas then for August 24th for a docket call. And hopefully that'll give us enough time to get all the misdemeanor cases up. We'll set them all on the same date so we can try to wrap them all up and get some kind of offer and hopefully a resolution to satisfy all cases.
Yes, Judge. Thank you. Judge, give me just a moment.
Yes, sir.
Thanks, Judge.
CR 16437, Basil Sotelo, set on motion to revoke.
Judge, we've been re-extended a 12-month state jail felony offer. This is a 2016 probated case. As I understand it, it's already set for a contested hearing on July 29th, 2021. And as I understand it from speaking with my client, she wishes at this time to consider both this offer and to proceed to that contested hearing.
She wants to reject the 12-month offer and then have the contested hearing on the 29th.
Yes, sir.
Okay. All right, then we'll see you on the 29th. And Mr. Ashmore, we have typically set everything at 9 o'clock in the morning. We are
Yes.
make a policy change on that. So I'm sorry if it conflicts with your schedule all, but we're gonna reset her to 1:30 that afternoon. And
Yes, Judge.
we found ourselves to be overextended both in the morning in the courthouse and using inmates. So we're going to try to keep the inmates at 1:30 and bail clients at 9 still.
I appreciate that, Judge. It's actually on my calendar for
Okay, good.
12:45 anyway, so.
Good. Okay. All right. So Ms. Sotelo, we'll see you on the 29th at 1:30.
Yes, ma'am.
All
Thanks, Judge.
You're welcome.
I think that's it for me. May I be excused, Your Honor?
Yes, sir. Thank you. I appreciate it.
Yes, Judge.
Thank you.
Thank you.
Thank you, Ms. Abraham.
Okay, we'll be back in a minute.
Okay.
Good night.
All right, court calls, cause number CR 2150, State versus Judson Taylor Brown. And we are set for sentencing today. And the court ordered the Van Zandt County Community Supervision and Corrections Department to prepare a pre-sentence investigation report that was requested by the defense. The court has received said report. Mr. Sanders, on behalf of Mr. Brown, have you received that report?
Yes, sir.
And when did you receive that? Did you receive it at least 3 days prior to today's hearing?
Yes.
All right. Ms. Heisel for the state, did you receive the report?
Yes, Your Honor.
At this time, are there any requested additions, deletions, or modifications from the defense,
No.
from the state?
None for the state, Your Honor.
All right, and Ms. Heisel, if you will present, I believe that there was an enhancement paragraph that was included in the indictment. In this case, went to trial, and that was not presented because the issue of punishment was not before the jury. So this time, will you present the enhancement paragraph of the indictment?
Yes, Your Honor. In cause number CR 20-00150 is further presented to the court prior to the commission of the aforesaid offense that on the 24th of June, 2014, in cause number CR 14-00052 in the 294th Judicial District Court of Van Zandt County, Texas, the defendant was convicted of the felony offense of burglary and habitation.
All right, and how does Mr. Brown plead, or does he plead true or not true to that? All right, the court will find that the enhancement paragraph on Mr. Brown's plea of true is true at this time. All right, is the state ready to begin with the presentation of any evidence on punishment?
Yes, Your Honor.
All right, go ahead.
Your Honor, this time we would call for state exhibit 1. This is the previous petition, Your Honor.
All right, and my recollection is this most likely was a state's exhibit 1 admitted in trial. As far as numbering for the trial, maybe perhaps we should mark this as a letter. Maybe we'll go state's exhibit A,
That would be great.
just so there's no confusion. All right, any objection to state's exhibit A as marked? All right, state's exhibit A, judgment of conviction by court in cause number CR 1452 is admitted. Anything,
State performance, all your corrections.
Sarelson? Oh, yeah. All right, if you'll raise your right hand, please. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got, please have a seat, get comfortable there, and make sure you get as close as you can to the microphone and adjust it however you need to. And then make sure you speak up loudly and clearly. Do your best not to talk over the attorneys. Counsel, I would ask that you also extend Ms. Harrelson that same privilege. Don't talk over her while she's trying to talk, so my court reporter can have a correct and clear transcript. Good, Seisel.
Thank you, Your Honor. Ms. Harrelson, will you spell your first last name correctly, please?
NATALYAHARRELSOD.
And what is your current job title?
I have the jail lieutenant and jail commissioner.
Is that for the Van Zandt County Sheriff's Department? Okay. Are you certified police officer?
No.
What certifications do you hold to be in your current position?
Intermediate and armed jailer and the jail commissioner certification.
And how long have you been in that position?
January 1 as the jail commissioner.
And in your business as jail administrator, what are some of your daily duties?
Overseeing the operation of the facility, inmates, officers, making sure their tasks are being completed. Request on grievances, there's a lot of different things.
In the Van Zandt County Jail, are the cells or the jail in any way equipped with a total?
Yes, almost all of them are.
And when you say almost all, where are those installed and what is the access to those?
Every housing unit does have one, and they're available to everyone in the house there. Holding and in talks when they initially come into the process, do not.
But once they're booked into jail and they've cleared those holding areas, then they're assigned, what did you call them, the housing unit?
Present
And how many people are in housing?
anywhere from 1, 4, 6, 8, or 24.
And do you oversee the operation of that telephone system?
Yes, ma'am.
Is that one of your job duties?
Yes, ma'am.
When they are when there's a telephone system in a housing unit, how does that work? Do they take turns using them?
Yes, it's kind of a first come, first served basis, unless there is video visitation, which can be scheduled.
How does the phone system work? If an inmate wants to place a call outside of Banton County Jail, briefly describe that process for us.
When they're booked in, our jail management system is open. They get to their housing unit and initially make their first phone call, have to change it to their own personal phone number, something that they can remember. And they'll enter it twice. It'll ask, the system will ask them to record their name. They're only allowed to do this one time to prevent remaining phone calls from happening. So they'll record that each time they make a phone call. That recording will be played the same thing recorded. And they will find down the area code and phone number and wait for those people.
Okay, and once the phones connect, is there any kind of message that plays over the phone system?
Yes, ma'am. The family and the inmate are both notified. All calls are subject to be recorded.
And then when a call is ongoing, how does the recording of that process work?
So it is stored on, I have to look, there's a server along here and it is our phone basis.
So can jail staff or anyone with access to that system listen in while a call is in progress, or do they have to wait until it's completed?
We can listen in progress.
Okay, but then once it's completed, it goes, is it like a cloud or?
Yes, ma'am. There's a server along here and then
Okay. And anyone in law enforcement who has access to that can listen to those calls, is that correct? As long as they have the identifiers for the particular person.
Yes, ma'am.
Okay. Your Honor, may I approach?
You may.
I am showing you, Lieutenant Harrelson, what's been marked as States Exhibit B. On here, do you see a defendant's name?
Judson Brown.
And do you recognize that defendant as someone who is current inmate of Banton County Jail?
Yes.
And is there any other identifying information on this list?
Date and time.
And if the phone system identified that date and time associated with any particular call, would that be true, correct information?
Yes, ma'am.
To your knowledge, does the Banton County jail phone system, has it had any kind of malfunctions that would prevent it from being accurate? In your experience, are all the recordings on there true and accurate, copies of all the calls that were placed?
Yes, ma'am.
Your Honor, at this time, I'm going to offer State's Exhibit B.
State's Exhibit B is admitted into evidence.
And Lieutenant Harrelson, will you read the date and time on this just please?
6/9/2021, 15/10, and 15.
And is that stored in military time?
Yes, ma'am.
So what time would that equate to?
3/10.
Okay, in the afternoon?
Yes, ma'am.
Your Honor, at this time, I would ask to publish State.
Granted. You may. No, I can make a gallery where you see everybody. Would you rather have that or just her? Ms. Heisel and Mr. Sanders, if you'll approach.
Last week. Or it's not working.
Yeah, I don't have it. I don't have a drive on mine. Tell you what, if you want to, we can take a brief recess and, well, actually, why don't you just come grab this one? There should be an HDMI.
Let's go back to the comments. I know there is a player essentially. See if I can burn. Player with it. It was working last week without it, but now it's not.
All right, we're gonna stand in recess for about 15, 20 minutes. Give Ms. Heisel an opportunity to access her evidence.
Hey, Judge, I was gonna say, I'm not gonna have any questions for Mr. Harrell, so I don't have a problem.
She's excused? Okay. St. Harrelson, you're free to go.
And if something changes where we do need her, we know how to get hold
We know where she's at.
of her.
All right, we'll stand in recess. I know it's about almost 3:30, so we'll stand in recess about 20 minutes.
The other option is that I would just use this judge, the other option is I can take directly from the system. It's the same recording. This is just on that preserve the evidence. For people, so.
Yeah, let's try the other alternative before we try that.
I have attached it, so at this time, state will play states.
All right, go ahead.
Phone calls are subject to monitoring and recording. You have 15 minutes of local call.
Hi.
And what is the matter?
Oh, I got found guilty.
You want to be this report?
Before.
Oh, they were calling saying on there.
Yesterday morning.
Yeah.
So up from 10, but got on the court.
Damn, Lord, they're here, well, some here.
I don't know. Not the fucking shoot back is very good. The citizen fucking, goddamn month later.
The what?
They're not doing the same thing as so fucking shoot back. I don't understand.
That's weird.
Yeah, I mean, like 30 fucking days to fucking, I don't get it. It doesn't take, why am I in jail? Like, okay, well, I'm walking out. Why fucking pull my bond? I showed up to court.
Did you pay your bond?
No,
That's why people brought to your thing.
that don't mean nothing. I did pay it though. I had paid it. I paid him fucking $200.
That's all you paid?
Yeah,
You remember you bought from your thing on the line?
it don't matter. It wasn't a bond that they came off my bond. It was the state, fucking the DA did that.
Where did it say? What it says is the name on it.
It said bond insufficient. The state she stood up, when I got found guilty, she stood up and said, Judge, the state also asked that the client, the guy, whatever, bond being found insufficient due to being found guilty. And the judge said, I agree. I find the defendant, bond to be insufficient and here to be taken into custody.
Yeah.
And then he gave me $150,000 fucking bond.
Yeah.
So,
I saw that. Okay, huge.
yeah, I'm like, man, he said, he got off, he says, I'm not saying, he come back later, told me I had $150,000 or whatever, he come back to my lawyer, he's like, something I thought it was. And he said, I'm trying to try to make this, you should have no problem paying any kind of fees. Because I think about $150,000, I fucking laughed. I mean, I was literally laughing out loud. I said, fuck, I keep fucking doing the right thing now, huh? Next time I won't show up.
And so what was it a jury call?
Yeah, I want the jury.
Yeah, okay, come on, you do that. Okay, you're they're gonna do more time now.
Don't give a fuck the calls. I'm for appeal already.
Wow.
Because I want to do it. I mean, what are you gonna do? I mean, you'll get in, okay, cool. And I'm been disputing money. That's all I'm going to file for the field, and then I'm going to file for another field, and I'm going to file for another field, and I'm going to file for another field.
So you're just asking for time for it, yeah, like,
Exactly, yeah, but they want it, it's really cool to me. Well, they're going to max me out at 20. Max me out at 20. Big is all you can do, but I can still figure your decision over and over and over.
and they say, and so, when, okay, I'm walking stuff,
So you got a little girl, huh?
I think she said, what about you, she breaks,
She's what? I'm bringing it on me.
repeat. June,
Barely.
she repeats, so that's why I'm trying to argue, like, she's like upside down and fucking curled up real fast.
I'll go down. She got nothing wrong.
So, wrong direction. She was like, one people drove there 150 and she was the all we're gonna go ahead and add anything about the next time to check off for bike parts and there, but from what was there, I saw it was like starting.
It's good. That's good.
Yeah, but then after you left stuff down on, like, split the game.
Yeah.
Yeah, I was just but yeah, it's like my big fears, like, I'm kind of still right, what's going on, big fears.
I'm on phone. You ain't gonna do that.
And so, yeah, I'm scared like that, huh?
Still Chris?
Yeah. And so, when comes to it,
I don't know. I think they're trying, I think my lawyer's trying to give you probation. Probation, it'll be the same, like a drug rehab, it takes the drug rehab, and then probation.
well, if you do that, you probably ask for stem work, you're not expecting forever.
Well, the year, my lawyer's already off, about to put out the section in court, but through the beginning county, I couldn't get released, there was in the court, and application's already, expired, just taking other,
Well, you do have one side that did show up for court and say, you know what I'm saying, that's not right.
what do you want to say? So what do you?
That's what I'm saying, it's like, so like, it's not like, you know, it's just the area of this thing, you know?
You too, and I am showing up for this thing again.
The stuff that we just fucking stop being and whatever, like, try to be that motivated, you know? Some people don't get that sense of whatever, like, you're from home, so you feel like, so what is this again?
The fuck you mean most people don't? A lot of people now get fucking probation with criminal history.
No, it's around.
No, they are. I know, it was fucking Coffee County, they put this stuff for your paper, and he's a 5-time loser. Been in prison 5 times.
And Carlton, maybe.
Coffee don't do that, Coffee ain't trying, Coffee gonna hang somebody.
I know.
You need to pick up, Carlton. Huh?
They ain't times like that, like that, you work on yourself.
I mean.
So you figure out what that new part thing is about?
What's charged?
Whatever the people are fucking wrong, saying whatever.
No.
You don't, I remember they were calling me and saying, like, whatever you said, you already talked to them, argue with them.
No, it is.
I that message about people fucking leaving me voice messages and saying that they're looking for you, they're first, you first, and fucking people talk to them.
Bullshit. Now, what? That's true. That's because I got money from the cash, like CD cash, and some fucking money cash fucking loans. And fucking as soon as I fucking motherfucker, like, my bank account, like, closed or whatever, I got sold, like, I pulled it out of my account, and then, my account, what, the first time that they go to charge me, for, like, the fee or whatever, my weekly payment, I got arrested, in county, and my fucking shit got shut down, my account got shut down, because, I had to add one other thing to get my account. So I shut my account down, I'm gonna shut my account down, and they charged my account trying to get it, and when they finally got rejected, over and over and over again. They closed my account, my solar account too, saying that I was paying on it. So they're trying to charge me with the fraudulent activity of trying to take the money with no intention of paying it back. If I got something over the phone, I said, look, I think I talked to them. I'm trying to talk to them like this, I've never been talked to them the day before. And I told that lady, I said, look, lady, I talked to somebody, I called him, it was 4:50 p.m. when I called him. And I talked to some guy, and he said that everybody does that, and he's the only one there, and then he's got to get access to the stuff, so I gave him the information, he got access to the account, and we sit there and we talked for about a good 30, 45 minutes. And he told me that he's gonna charge me with this and another because of this, and I told him that he could suck my dick and fucking lick my balls and hold my tongue because I wasn't trying to fucking run it off. I got arrested, therefore I still make payments because I was arrested in jail. What you want me to do, call me from a phone number? And she kind of laughed, and she said, okay, well, let's do it, I think it's too hard, we'll charge you again. I said, Chauncey, go ahead, go on, hit me with it. I don't give a fuck. Stuff I need.
Yeah. So you don't need to share anymore, huh?
No, I don't. Everything's looking, technically, all my pictures and stuff that I saw.
Just for the record, I'm gonna stop playing at 10 minutes and 7 seconds. The remainder of the call is not related to the criminal case in any way. And so I'm gonna stop playing at this point.
Okay.
Your Honor, stay the rest of this time.
All right, thank you, Ms. Heisel. Mr. Sanders, any evidence on behalf of the defense?
No, Your Honor. It's the rest.
Ms. Heisel, would you like closing argument?
Yes, Your Honor.
Go ahead.
Thank you. Judge, as you can hear from the jail call, and I do believe that that is how Mr. Brown really perceives the judicial process. When he's in court and he's in front of all of us, he's one person. However, I believe that the jail calls reflect his true attitude, which is that this is everyone's fault but his. It's my fault for wanting to give him too much time. It's your fault for holding his bond insufficient, even though he was 2 hours late to an evading arrest of motor vehicle charge for which he was found guilty. Judge, you will see in the pre-sentence investigation report, Mr. Brown has before been put on probation and was unsuccessful. He has been offered drug treatment before and was unsuccessful. Judge, he went to prison for 8 years, sentenced out of this very court. While on parole, almost immediately upon being released for parole, he immediately picks up new charges that result in a blue warrant. On the night in question, he's, by his own admission at PSI, doing a drug deal. When he gets pulled over, knowing he has warrants, and decides to lead officers on a 50-mile chase, near 50-mile chase, putting other people at risk without any regard for anybody but him, because he didn't want to go back to jail. Everything is about Judson Brown, yet nothing is Judson Brown's fault. Your Honor, he was on parole for that 8-year sentence when he picked up these new charges. So we're going to ask that you sentence him to 16 years. Hopefully that time will encourage him to start taking some responsibility for his actions and for his life. And hopefully he will come out a more productive member of society than he is now.
Thank you, Ms. Heisel. Mr. Sanders?
Judge, as far as the phone call, I think it's noted this was the day after we finished the jury trial. Obviously, he was upset. I think he was probably more upset that he had lost his freedom and bond was found insufficient while he was waiting sentencing. I think it's understandable that he was mad. Probably should have been, but that's kind of, I think, on the heels of being found guilty and on the heels of being back in jail. So it's not surprising he was upset about it. I think that what's maybe more revealing is in the PSI where he gives his version of the events. Towards the bottom, it says that looking back at the situation, it made no sense to run. It wasn't worth putting himself or others at risk. I think that since he's had time to reflect on that over almost a year, right around a year, I think he realizes that it was extremely foolish in doing what he did. Probably what's more relevant is he was honest about what was going on that night and honest about the whole issue with drugs. I think that while he's got some priors, whether he was actually ever convicted at the time or just they were dismissed for 45, I think so much of his history, some way or another, is connected with drug use, abuse. I don't think he would deny at all that that's been a big problem for years. And even talking with family, I think that's an issue. I think I And as I said, after the trial, whenever we're talking about the bond issue, that family had gotten approved to go to Singapore while he was still in jail and these charges, as well as I think at that point the Dallas County cases had not been dismissed yet. But that was something they're definitely looking into. Judge, as far as the time, I think when he was sentenced on the burglary application back around 2014, I believe he did about 3 years, so he'd been out a couple of years before picking up these new charges. And I know that still doesn't sound that great, but I think too, is that we can see the drug use was a big part of things. I mean, it has been. I know that ultimately he's got to be the one to make that decision, and that's going to be part of his life. But that's why we are asking for an opportunity on probation with the opportunity to go to inpatient treatment, safety, whatever the court sees fit, simply because to this point, nothing else has made a difference. And I don't think he's been to safety. And I think that that's something that he would acknowledge, and I think that's pretty clear that there is a need for drug treatment to put these issues behind him and then move forward. I think you can see from the PSI, he comes from a supportive family. And I think he would admit that there's just been decisions along the way where he's made it, where he just it's gone off track and doing foolish things he shouldn't be doing. And there's no denying that. That's, there's no excuse for any of that. But we're asking for the opportunity with probation to go to inpatient drug treatment. And judge, alternatively, if the court doesn't see fit to do that, we would ask for a TD sentence somewhere in the range of 6 to 8 years, somewhere in that time frame, just based on the circumstance of this case. I think based on his acknowledgement of being upfront in the PSI with what was going on that night and realizing how foolish that was. And so based on that, if the court does not see fit to grant probation and inpatient treatment, then we would ask for a TDC sentence somewhere, like I said, in the range of 6 to 8 years.
Thank you, Mr. Sanders. Any follow up, Ms. Heisel?
Just briefly, Your Honor. Judge, I would just ask you to pay special attention to that PSI. Look at the opportunities that he's already been given. Reflect. I admit, maybe he was a little more inflamed at that time than he is here today. But again, I believe those words at the time were his true feelings on the judicial process. That to me does not sound like somebody wants help. Stay with after 16.
Thank you, Ms. Heisel. All right, of course, going to stand in recess for a short period of time so I can review the evidence and the arguments that's presented. I'll be back soon. All right, we are back on the record in cause number CR 2150, State of Texas versus Judson Brown. Mr. Brown, you appeared before this court on June 7th, I believe, of 2021, and a jury found you guilty of the found you guilty of evading arrest with a motor vehicle. The state filed a notice of enhancement in the indictment to which you have pled true, and the court has found that to be true. Court finds that the range of punishment for this is now a second-degree felony with a punishment range of 2 years to 20 years and a fine not to exceed $10,000. The court, having received the punishment evidence in this case, has also considered the pre-sentence investigation report prepared by Officer Carl Waddell of the Van Zandt County Community Supervision and Corrections Department. After reviewing the evidence and the arguments and the pre-sentence investigation report, I'll tell you, Mr. Brown, that it might surprise you to know that hearing the state's Exhibit B did not cause me to have an emotional reaction to your words. I believe that Mr. Sanders makes a good argument that you were in an emotional state that day, considering your circumstances, and I believe that the state even conceded the same. So it does not cause me to have an emotional reaction in considering your sentence. I want to tell you that I'm not going to grant you probation today, okay? And the reason I'm not is because I look at your history and I see here a multitude of poor decisions that you've made, and you've continued on that track. And unfortunately, I don't trust that I can put you into the community and expect you to not continue to make those same type of decisions. And therefore, I do not believe that you would be a good risk for this community that we live in and that I feel I have an oath also to protect. So I'll tell you, Mr. Brown, that a lot of my focus in determining what I believe to be a just punishment for this case not only is reflected in your criminal history, but more so on the acts that you committed in this offense. Reckless endangerment of not only your life, but the life of those around you. I understand that you have a son. I understand that you have a supportive family, and I know they love you. And so you put your life at risk that night, but more so you put the lives of the officers at risk on such a high speed and long enduring chase that is pretty, that's pretty significant in my mind. So Mr. Brown, the court, in considering all of the evidence, believes that you should be punished at a sentence of 13 years confinement in the Texas Department of Criminal Justice Institutional Division. I'm going to assess a fine of $1,500, order you to pay court costs and reimbursement to Van Zandt County. And I'm going to award you all the credit time that you have earned while you've been sitting in jail on this case, waiting for trial and waiting for the sentencing today. It's my hope that when you get out, and you're going to get out, you were in TDC before and you were granted parole. It's my hope, Mr. Brown, that when you get out, that you will think back upon today and realize that the actions that you make and take after being released are going to affect your future. And you can decide when you leave today if you want the rest of your life to be in and out of prison, to be in and out of your son's life, your family's life. And I hope that's not the decision you make. And I hope that you can understand why I believe that this is a just sentence here today. And if you can, I understand that and I accept that. I don't expect you to, I just hope that you can. Okay. Mr. Brown, do you have any legal reason why sentence should not be imposed against you today? Mr. Sanders? Okay. All right. Then, Mr. Brown, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. State, I'm going to ask you to prepare an order, provide that to Mr. Sanders so he can ensure that it's accurately reflects Mr. Brown's credit time. And then we will make arrangement to have Mr. Brown fingerprinted at the Van Zandt County Justice Center. All right, so if you can just prepare that within a few days, then we can, it doesn't have to be today. It's 5 o'clock. So as long as you'll provide it to Mr. Sanders via email, and then we can take it over to the jail and have Mr. Brown fingerprinted. So there's no need to keep her around today. If there's nothing further from the state or from the defense, then we'll be adjourned in this matter. Good luck to you, sir.
Thank you, sir.
You're welcome. Thank you for your help today. I appreciate it, sir.